Good afternoon, everyone. I apologize for the slight delay there. I'm having some issues with Facebook Live and can't seem to get it working, unfortunately. I apologize for the delay. Thank you all for joining us. My name is Matt Gagel. I'm the Director of Programs here at Montgomery History. I'm glad that you've all joined us. And before we get started, just a few things to go over here real quick. First of all, as you are those of you who got in wouldn't be aware, but we're rapidly and regularly hitting our max max attendance for these programs. So normally I would suggest going to Facebook if somehow you're disconnected or aren't able to get in the future. Hopefully that will be resolved. We're looking at a few other solutions. But we do always post the recording of the presentation on our website for you to check out, and you can check out last week's presentation about the DC trolley story on our website as well. That'll be up there through next Monday. Again, I'd like to thank everyone for being here. My name is Matt Gagel. I'm the Director of Programs, and again, glad you're here. I would like to thank everyone who's made a financial contribution to Montgomery History recently. We would not be able to do these programs without you, and for that we're extremely grateful, and we are very glad and hope to continue to offer these programs. If you have any questions, you can use the Q&A function. Those will go to me, and I will be reading those at the end of the presentation. If you have any technical questions, use the Q&A as well, and I will get those, we'll address those technical questions as they come up, and then we'll do the Q&A at the end. Next week, we'll be doing a rewind of an event we had back in 2016 with Stephen Cokie Roberts. I think that should be a great presentation, kind of dealing with the historical aspect of the elections. And then the week after that, Eileen McGuckian and Susan Soderberg will be joining us to give a presentation on the 156th anniversary of Emancipation Day here in Maryland. All right, I think that's it. Jim, are you there?
I am.
Okay. All right, I believe we should be able to see Jim now. Yep, there he is. Okay. All right. I apologize. That sounds like there is some lawn maintenance going on outside, if you can hear that, but I'll shortly mute my microphone. Jim, whenever you're ready, you can go ahead and get started there.
Okay. I'll put my screen share on and we'll go with it. And then I have to do present. Thank you all for joining us this afternoon. I'm going to talk about William Marbury, the man who made the Supreme Court supreme. This was an article I did, it's based on an article I did in 2005 for a legal newspaper. And I tried to look at more about Marbury, the man, who was a Marylander and for a time in Montgomery County. But as we go through this, you're going to see that I did a lot of interesting research that took me in other directions. I'm going to talk about biography. I'm going to talk about history. I'm going to talk about politics. I'm going to talk a lot about law, but I hope not to bore you. But I also will talk a bit about art. That's more towards the end, but that's the whole ball of wax of what I'm going to do today. And let me start with the case Marbury versus Madison. For lawyers, this is the principal case in constitutional law. It stands for the proposition that the Supreme Court is the one who decides whether laws are constitutional or not. And it was this case that did it. There was a hole in the Constitution. The founders never thought about this problem, and this case resolved it. But let me turn now first to the man, William Marbury. He was born in Prince George's County in 1762 to a tobacco farmer and his wife. You know, that was the time that England was passing what were called the Intolerable Acts, and the things they were doing were targeting tobacco a lot. And so tobacco farmers had a very tough time economically. The result was that 3 of Marbury's brothers joined the American Revolution, and Marbury was too young, but it left him with a burning ambition to make money. At age 19, he went to the big city of Annapolis, where he landed a job as a clerk for the state auditor. Then he worked as a tax collector in Charles County and Anne Arundel County before returning to Annapolis as agent for the state. This was a very unique position I don't think we have now. He was basically the stockbroker for the state of Maryland. He wouldn't invest in stock, but he would take the money, that tax money that came in, and before it was spent, while it was sitting in the treasurer, he would invest it in bonds and banks and interest-bearing accounts. And the important thing for him was that he made a commission off each of those transactions. So he became very wealthy. We don't think about it, the fact that at the time, not many people in America could read, and even fewer could do arithmetic. And Marbury could, and he had this knack for accounting and arithmetic, and that was his route to success. He was considered honest, but one of the things we'll talk about is ethics at the time. If you look at this portrait, this is a miniature by James Peale, the brother of Charles Wilson Peale. Shows a fairly young Marbury. He's clearly a man that does not work with his hands. He does not work outside. He's an accountant. He's the agent for the state. So this roughly 1790, and he's in Annapolis. Now the scene's going to change to Georgetown. And I'm using Google Earth to show you Georgetown. It founded in 1750. As Maryland developed, it became the closest port to the western part of the county. Ocean-going ships could come in here. And I'm going to talk about two men. One was Benjamin Stoddard, who lived at this house, and I'll show you a close-up. And this is the Key Bridge. And then if you walk down the street, you get to Uriah Forrest House, which is right here. And again, I'll show you those pictures. But these men, are living within a block of each other. Francis Scott Key's house was right here. That's why this is called the Key Bridge. This is Benjamin Stoddard. His father was a ship captain. He married the daughter of a transatlantic slave trader, so he had money and shipping in his blood. Well, he had money in his pocket, and he had a shipping in his blood. He fought in the American Revolution and did well. He was wounded, and when the revolution was over, he settled in Georgetown at this house. It's still there. It's called Prospect, on Prospect Street. I think that probably his house was a smaller version of this, but this is always considered Benjamin Stoddard's house. I'm going to do a little bit of art just because I like it. This is The Stoddard Children by Charles Wilson Peale. It hangs at Dunbarton House in Georgetown, but that's not the reason I'm showing it to you. I'm showing it to you because in the background, you can see the port of Georgetown, and you can see what is not there, and what is not there is Uriah Forrest House, which I'm going to show you. Uriah Forrest was an aide-de-camp to George Washington. He lost a leg in the Revolution, and this is his house in Georgetown today. It's called the Forrest Marbury House because Marbury would buy this house. The flag is of Ukraine, and this is the Embassy of Ukraine. So Forrest and Stoddard were very good friends with George Washington from the Revolution. And then after the Revolution in 1784, when Washington started going into business and developing the Potomac Canal, they became very good business friends with him. After he got elected president, he decided Congress decided that they were going to move the capital from Philadelphia to Washington, D.C., or to the boundary between Maryland and Virginia. And they gave George Washington the right to decide precisely where it would be because they wanted it to be close to his house at Mount Vernon. So he decided generally on the district of what is now the District of Columbia, but they needed help in purchasing that land. Forrest and Stoddard and a man named William Deakins all were secretly buying up land because the federal government didn't have that much money and it didn't want land prices to go up. And so they secretly bought up a lot of land, which they resold to the federal government. But they had this big dinner at Uriah Forrest House in 1791, where they brought in the 19 landowners that they were still negotiating with. And Washington sort of put the hammer down on them and got them to sell the land to the federal government. So this house has this historic value as the place where they had the dinner that created the District of Columbia. Stoddard and Forrest, and we get into ethics now, although they had helped Washington buy up the land, they realized that the land would go up in value, and they were land speculators. So they formed a bank called the Columbia Bank of Georgetown, and its function was to hold money, which they would then borrow from that bank. They'd buy land in speculation and sell it at higher prices as the District of Columbia, as the government started building here and as the capital moved here. They thought they'd make a lot of money. The trouble was that got them in the banking business, and the big banks were in Baltimore. And there was a banking cabal up there run by a man named Samuel Chase. And the banking cabal and Samuel Chase went to Annapolis, and they said to the state legislature, we'd like you to deposit the state funds in our banks. And we'd like you to deposit 180,000 in our banks. And so the state legislature was debating this. To the Columbia Bank of Georgetown, it was a threat to their existence, because that would mean, Baltimore banks would really dominate Maryland banking. But again, supposedly honest William Marbury was asked by the state legislature what he thought, and he wrote the state legislature and said, I don't think you should invest your money in the Baltimore banks. I can make more money by investing in US Treasury notes, and that ended the attempt to do that. He made an enemy of Samuel Chase, but he made good friends with Stoddard and Forrest in Georgetown. And then in 1796, John Adams became president through the election. And this is a Benjamin Blythe portrait of him. I like this simply because it's so crude, and I'll show you better ones later, but this is to give some variety. So he became president. And, he had been leading the American Revolution in the Continental Congress. And he always had this view that the British Navy was so powerful that we didn't have much of a chance to fight the British at sea. And so he talked about the idea of a wooden wall of ships. And that came from ancient Athens, when the ancient Greeks had their ships and they became a naval power in the Mediterranean. And Adams borrowed that phrase, and he, as president in 1797, wanted to start building a wooden wall of ships. So he picked Benjamin Stoddard as the first Secretary of the Navy to do that. And Stoddard proved good. He turned a 3-ship Navy into a 39-ship Navy in 4 years. He put up Navy yards, including the Washington Navy Yard, to build those ships. But his investments in the Columbia Bank of Georgetown were a problem for him. He was in debt a great deal, and by 1797, he needed $9,000. So he turned to William Marbury, who was still in Annapolis, and borrowed $9,000 from him, and he secured it with a mortgage on 17,345 acres in Western Maryland. He eventually defaulted on that, and Marbury took possession of that land. But I'll digress just a bit, because again, on this ethics as to how Stoddard got 17,000 acres in Western Maryland. He was an officer in the American Revolution. The Continental Congress didn't have enough cash to pay the troops. So on payday, the troops would appear before the paymaster, and he would issue them deeds to land in Western Maryland. And the average soldier couldn't do much with a deed, piece of paper, on payday. He'd rather have cash. So as he walked out of the paymaster's tent or wherever, Stoddard's men would be there with cash, and they'd say, hey, soldier, you want to sell us a deed? And they'd pay 10 cents, 20 cents on the dollar. And that's how Stoddard acquired all this land, by buying the land from his troops during the Revolution. In 1798, Stoddard made Marbury a director of the Columbia Bank of Georgetown. And in 1799, he had Marbury move from Annapolis to Georgetown and become the agent for the Navy Yard, the Washington Navy Yard. Marbury bought Forrest House, and therefore it's today called the Forrest Marbury House. He was a real social climber, and he wanted to be prominent in Georgetown. One of his claims to fame was to be manager of the dance assemblies. There wasn't much to do at night or on weekends in Georgetown, And so with his big house there, he would manage the dancing at the house. At the Navy Yard, he became pretty good. As an accountant, that was claimed that a contractor was billing the government $1 a day for a subcontractor and only paying the subcontractor 66 cents. Marbury caught it and made the contractor cough up the money. He discovered that the head of the Navy Yard was using government iron to improve his house. And again, Marbury made him pay for it. So sort of this petty kind of honesty, ethics, but he was still making money and he had a very big house in Georgetown. So he and Stoddard are close buddies. He's on the Columbia, he's director of the Columbia Bank of Georgetown, and 1800 rolls around and Thomas Jefferson decides he's going to run for president against Sam Adams. And the political parties then were, Adams was a Federalist, that today is the Republican Party. Jefferson was a Republican, which was today the Democratic Party. So I'm going to use the old terms, Federalist and Republicans. So Jefferson's running for president against Adams. Marbury and Stoddard are backing Adams, obviously. So, today we have this, we all are familiar with the problem of the Electoral College. And so it was around even in 1800. And there are two ways for a state's electors to be allocated. One is winner take all. If John Adams won the state of Maryland, then he got all the electoral votes. The other was to award the electoral votes by congressional district. So if, for example, Montgomery County is in the 8th congressional district today, whoever won the 8th congressional district would get one elector for that district. In 1800, Maryland electors were awarded by congressional district. John Adams' people figured that they could win the state of Maryland, all the electors of the state of Maryland, if voting was done at large. And so they tried to get a law passed through the Maryland legislature to do that. Stoddard and Marbury were caught promising someone a position in the second term of the Adams administration if he went with them. So there was this little mini scandal that hit the papers that Stoddard and Marbury were doing underhanded deeds to help Adams win the election. To show you how Jefferson won the election, but this shows you how important that was. The green states are those won by Jefferson. The pink states, the salmon states, are those won by Adams. And you can see some of those states are split because of the vote went by congressional district. And here is a tabulation of it. And you can see how important that scheme would have been. Jefferson won 73 to 65 electoral votes, but he got 5 out of Maryland. If Maryland had been winner take all, Jefferson would have gotten 0 and his total vote would have been 68. Adams would have gotten 10, so his total vote would have been 70. So Adams would have won the election if this little scheme that Stoddard and Marbury had going worked. Now, there's no evidence really that Thomas Jefferson knew specifically that Marbury was involved in this. He undoubtedly knew that Stoddard was involved in all sorts of stuff. But in the 1800 election, Jefferson won, and so he's going to become president. In those days, the elections were like today in early November, but the inauguration wasn't until early March. And so between losing the election and March, John Adams, and this is a Charles Wilson Peel portrait, you can see he's much better. John Adams was president. Moreover, the Federalists had not only the presidency, but they also had a majority in Congress. So they realized that having lost the election, they lost not only the presidency, they lost Congress, so they were going to be out of power. But there are 3 branches of government. And they decided that one of the ways to retain power once they were out of office was to take control of the judicial branch of government. And therefore they passed a law called the Judiciary Act. in 1801, which created a whole bunch of new judgeships in the federal court system. And then when it got down to the District of Columbia, as a new, the District of Columbia had just been formed, it created these justices of the peace. And there were 23 positions in the District of Columbia and Georgetown, and 17 of those in Alexandria. And the justice of the peace wasn't someone who married people. It was a fairly important position. It had criminal authority. If you were arrested for a crime, you went before a justice of the peace who would decide whether you would be charged with the crime and have to stand trial. And he would also decide whether you went to jail or you could get out on bail. Even more importantly, they had a civil function, an administrative function, where they decided how the tax money should be spent. And in those days, tax money was usually spent on roads. Therefore, the Columbia Bank of Georgetown and its directors, who were speculating in land, had a great interest in being justices of the peace because they could put roads up to their real estate developments. So under this act, the President Adams got the right to appoint all these new judges, which he did, and he got the right to appoint these justices of the peace, which he did, and the Senate confirmed them. But at the very last day or two before he left office, Adams needed to actually sign a thing called a commission. And here's one I've just got off the internet of Barack Obama. This is the way an officer of the federal government gets his position. He needs a piece of paper signed by the president. So Adams signed all these commissions for these justices of the peace, and he turned them over to the Secretary of State, who was at that time the person who would manage the federal government and handle all the details of managing the government. And the Secretary of State was supposed to deliver these commissions to the justices of the peace. Well, there was a snowstorm, so some of them didn't get delivered. At the time, John Marshall was the Chief Justice of the not Chief Justice, he was the Secretary of State. And his brother, James Marshall, was sort of a courier. And so John Marshall gave these commissions to his brother to deliver. And James Marshall said later, he thought it was more important to get some out to Alexandria because Alexandria was a pretty licentious place and they needed justices of the peace. So he delivered some to Alexandria, but most of them did not get delivered, including William Marbury's. And William Marbury was a director of the Columbia Bank of Georgetown. The other directors who got Justice of the Peace positions were Stoddard, Uriah Forrest's nephew, and 3 other directors of that bank. So 7 of the 23 Justices of the Peace were on the Columbia Bank of Georgetown to protect their real estate investment. So Marshall is the Secretary of State that doesn't do it. And by the time March 4th, when Jefferson gets sworn in, John Marshall has become Chief Justice of the United States, and he swears in the new president, Thomas Jefferson. When Thomas Jefferson gets into office, his acting Secretary of State comes to him a few days later and he says, "I found all these commissions for justices of the peace. They're just laying around the State Department. What should I do with them?" And Jefferson said, "Throw them away." Jefferson was very mad at the Federalist attempt to they did pack the federal court system. And he certainly wasn't going to participate in any of this nonsense of letting these justices of the peace get their commissions. He then turned around. I don't think he had any particular gripe at the justices as individuals. And in fact, he passed a new law giving positions of 15 justices of the peace instead of 23. But of the 15 new justices of the peace, 12 of them had been on Adams' list. So this was all a tempest in a teapot. The trouble was Jefferson messed with the wrong man in William Marbury because William Marbury had enough money to do something about it. And he filed a lawsuit this is the opinion, but in December of 1801, he and some other of these uncommissioned justices of the peace filed a lawsuit to force Madison to give them their commissions. And therefore it's Marbury versus Madison. In fact, it was Adams versus Jefferson. It was a continuing battle between the Federalists and the Republicans as to who could control things. Now, the case then lands in the Supreme Court because the law at the time said any case where a cabinet secretary of state is sued should go to the Supreme Court. John Marshall by this time has become Chief Justice of the Supreme Court. So there are a lot of these conflicts going on. For example, there's a John Marshall letter to his brother, March 18th, 1801, just about 14 days after everything happened, saying, I didn't send out these commissions because I didn't think it was important. Some people have said that actually John Marshall was trying to suborn perjury. He was trying to tell his brother how to testify in this case if it came up. But in any event, John Marshall has been involved in the case, yet as Supreme Court Chief Justice, he's going to rule on it. Marbury's attorney was Charles Lee, who had been John Adams' Attorney General. And unfortunately for Marbury, one of the new justices on the Supreme Court was Samuel Chase, the banker in Baltimore, whose bill he had killed years earlier. So he didn't have a lot of friends. He certainly didn't have that friend on the Supreme Court. And of course, James Marshall was the Chief Justice's brother, and he testified in the case. The way this actually worked was they appointed a special master at the Supreme Court to take all the evidence. And then it went up to the justices to make a decision. This was 1801, but the decision didn't come down until February of 1803. Now, the basic issue in the case, everybody thought, was whether the commissions could be withheld by Jefferson. And in deciding the case, Marbury versus Madison, John Marshall went out of the way to say, yes, these commissions were valid. It didn't depend on delivery of the piece of paper. It depended upon John Adams signing them. Therefore, once John Adams signed these commissions, once he signed William Marbury's commission, Marbury was entitled to be a justice of the peace. Well, and he and I obviously prejudged that in this March 18th, 1801 letter. But John Marshall knew something else. He knew there was this big hole in the Constitution. And the hole was that the Constitution didn't specify which branch of government should enforce it. If a law was considered unconstitutional, who was to decide that? And so Marshall looked at this provision in the Constitution about jurisdiction, and that is what cases a court can decide. And the Constitution said, in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction. Yet the law under which Marbury was suing gave original jurisdiction in the Supreme Court. And Marshall said, okay, that's unconstitutional. So I've already ruled that Marbury gets the commission, but I've ruled that the statute under which he's suing is unconstitutional. And so the question is, who decides that? In England, Parliament decides that. If you believe something in England is unconstitutional, you work it through the court system, and then ultimately, if you want to pursue it, you can actually go to the House of Lords and ask for them to rule it's unconstitutional. The president could be the one who decides laws are unconstitutional. He, in fact, is charged with enforcing the law. The president could very well say this law is unconstitutional. Be a little silly since he signed it, but that's possible too. But Marshall said in Marbury versus Madison, the Supreme Court is the one who decides this because all the court system decides all sorts of questions of law. Therefore, we decide whether laws are constitutional or not, and we hereby declare this law that gave jurisdiction to the Supreme Court is contrary to the Constitution. And Mr. Marbury, you were right. You're completely entitled to that commission as a justice of the peace, but you brought the case in the wrong court. You're free to go back to another lower federal court. By this time, which was 1803, Marbury was fed up with it, and he had better things to do. He had tried to teach Jefferson a lesson, and he had failed. Now let me go back to William Marbury's personal life. He had this house in Georgetown. He's now hopefully in heaven, so we're having a view of Washington, D.C. as he sees it from heaven. His house was right here at the bottom of this. This is Roosevelt Island. Here's Georgetown. He had been agent of the Navy Yard down here. And Marbury was a pretty savvy man in many respects, certainly as an accountant. But he thought that the District of Columbia would move south, and therefore he bought hundreds of acres along here, south of the Anacostia, across from the airport. And he thought that that's where the government, or where the city would grow. It was called Boo Plain or Bow Plain. Today we call it Blue Plains, and we send our sewage there. So he wasn't that savvy. He did invest in the Navy toll bridge, Navy Yard toll bridge. He invested in the Rockville Pike. When I was doing my research, though, I decided to go to the National Archives and see what they had on his will and the inventory of his estate. And so I did, and I found, to my surprise, this document. He had slaves. This is the list of the slaves he had. The bottom number there is $10,000 in 1834 dollars. I estimated today that would be worth $2 million. And then his will freed one of the slaves called Hamilton, who was his personal servant. And you know, in those days, after the funeral or a few days after the funeral, everyone would gather for the lawyer to read the will, so all the family members would see what they got. And I imagined in my head this gathering, since I'm a lawyer, the gathering around of the family to read the will. Probably would have told Hamilton to come, because he might be getting something under the will, and he might be the only African American in the room. And I'm reading it, and I say, to my beloved servant Hamilton, I give him his freedom. And Hamilton is about ready to celebrate, and then I continue and say, in 7 years. So Marbury could be somewhat generous, but not fully generous. And you can imagine Hamilton's disappointment at that. He was also, although he continued on as a director of the Columbia Bank of Georgetown, he also became a director of the Competing Farmers and Mechanics Bank in Georgetown. So he's a director of competing banks. And again, the ethics of the time allowed that. We go back to Marbury's house today in Georgetown. His wife was Anne Odell Brewer. She was the niece of Charles Willson Peale, the artist. And so Peale often, I mean, not his niece, he was, Anne Odell Brewer was the niece of Charles Willson Peale's first wife, Rachel Brewer. She had passed away. Peale married several more times. But every time Peale went to Georgetown, he'd stop by and see them, see his niece. And next door lived Joseph Brewer, who was Rachel Brewer's nephew. So brother and sister lived in these two houses, and it gave Peale a chance to see them whenever he went to Georgetown. And he was there in 1818 and wrote about Marbury. This is from his diary. We went to a tea party at Colonel Marbury's, where there was about 3 dozen ladies and not quite so many gentlemen. They danced cotillion and country dances by the music of a piano, which was distinctly heard as the company danced on carpets. The entertainment was sumptuous and elegant. Colonel Marbury is wealthy and can make such entertainments with perhaps less expense than many others, having an abundance of fruit from his farms, also eggs, and his notable wife has the cakes made at home. However, with the best economy, such entertainments are very expensive, and the example too often followed by those whose circumstances are not in condition to bear the cost. With weak minds, fashion has two fascinating charms. This was December 1818. And what Peel is saying is Marbury puts on these lavish parties, but don't try to emulate him. Only people with weak minds would try to put on such a fancy party as Marbury does. When I was doing my research in 2005, Ukraine had just elected had its first real democratic election, and they were elated with their newfound democracy. And I wanted to look into this house, so I called up and said, "Can I come into the house?" And the cultural minister said yes. So this is the tour of the house. This is where they restored it to look like it did when Marbury owns it. Here's the ballroom where 36 ladies and not so many gentlemen danced on carpets for the cotillion and country dances by the music of a piano which could be distinctly heard. This is where it happened. And this is pretty much how it looked, they think. She took me in, the cultural minister took me into this next room. This is the room where Washington's dinner was held. And Ukraine felt that George Washington was their model, and they had just sort of finally fulfilled in 2005 what Washington had done in 1784. And on the table here, I always like to show this because they had lovely put out some cookies and water for me and for my arduous tour through their house. On the other half of this same room, there's the piano, which they did. They're George Washington. They were really proud of this room, and I suspect are today, because it's the room where Washington made the District of Columbia. To me, of course, it wasn't that important, but to Ukraine, it was a lot. And they also had on the wall this quote from Taras Shevchenko, the Bard of Ukraine in 1857, "You miserable crew, when will you breath your last? When shall we get ourselves a Washington with a new and just law? But someday we shall surely find him." And I said, well, this is wonderful, except you should add an E to breath, and it's breathe your last. But this was the spirit in the embassy at the time. And they also had this photograph, which is a poor photograph by me, of John Marbury, William Marbury's son, who owned the house after his father passed away and continued to own it until the late 1800s. But I'm not done. Now we go to the real art. This is a portrait of William Marbury as an older man. It's attributed to Rembrandt Peale, and I asked art historians about it, and one, David Meshet, said, "It does not show as fine a skilled a hand as the Peale." So I asked another Peale expert, Carol Soltis, at the Philadelphia Museum of Art, and she said, it's been touched up, retouched, and lacquered so much, you can't find the things you'd be looking for to verify it. So I would say it's attributed to Peale, but it's not necessarily, Rembrandt Peale. I said Charles Wilson. It's a Rembrandt Peale, his son. Well, this portrait has its own history. It now hangs in the Supreme Court. And I'll tell you that story in a minute. But first, I want to tell you that I was giving this talk several years ago. And in the question and answer period, a woman raised her hand and she said, "That portrait hung in our dining room. My father was Richard Marshall. He's a descendant of John Marshall. My mother, Florence, is a descendant of William Marbury. We own that portrait, and my parents gave that to the Supreme Court in 1979, but I ate dinner under that portrait for my childhood." In 1979, Warren Burger was Chief Justice, and he had just redone the Justice's dining room, and he wanted a portrait to hang there, and so he acquired this portrait to hang in that dining room. I took a picture of it in the Supreme Court, and I looked at that dining room. There are all these, 9 justices, 9 chairs around a dining table. They are all period pieces, antiques. I'm about 5'10", 5'11", and I looked at these chairs and I thought I'd never fit in those, but I imagined Justice Ginsburg who is a small woman, would have fit in those chairs. But this is in the this is the justice dining room. I don't think the justices get along well enough to all 9 of them sit down and eat in that room. I think they would probably fight. Maybe they do. But I was told by my guide that the justices really would invite friends and relatives in for lunch or dinner, and you had to be a justice to order the space there, but it wasn't always used for collegial meetings of all the court justices. Chief Justice Berger, who put this up, wrote a book in which he wrote about the Marbury case, and he called Marbury a ward-level political figure. I think from what you've heard, that wasn't true. He was a very wealthy Federalist who was trying to teach Jefferson a lesson. But after this justice's dining room gets done, they get the Marbury portrait. Berger thinks, well, you know, I need another portrait. I need a Madison portrait. And so he gets this portrait. It's a James Frothingham portrait of James Madison. And Frothingham was a student of Gilbert Stuart. So in the justice's dining room, I show this. This is another portrait of James Madison by Charles Wilson Peel, because I like Peel. So there's Frothingham Madison, there's the Peel Madison. But if you're a justice of the United States Supreme Court and you sit in the dining room there, these portraits don't hang adjacent like this, but they are the only 2 portraits in the room. And I think it's a lesson by Warren Berger that says to new justices, don't think small. John Marshall took this tiny little case involving this justice of the peace in Georgetown, and he made it the most important case in constitutional law, and he closed a hole in the Constitution. Now, before I end, I want to show you a couple of things about it. Since there have been the Supreme Court hearings the hearings last week on Judge Barrett, who is an originalist, you see, I don't believe in that. And you see what happens in Marbury versus Madison. This is some language at the top. The theory is essentially attached to a written constitution. It is emphatically the province and duty of the judicial department to say what the law is. It's a fundamental principle of our society. In Marbury versus Madison, they pay no attention to the original intent in the Constitution. They just say it's a fundamental principle. And so originalists who try to declare laws unconstitutional as not fitting the original intent are relying on a case that didn't use originalism. And in Roe v. Wade, it's the same thing. The court there in the abortion case recited a bunch of decisions, and it said the decision make it clear that only personal rights that can be deemed fundamental or implicit in the concept of ordered liberty. It's the same kind of concept that Marshall used in Marbury versus Madison, where you're not going to the specific language of the Constitution or specific principles, you're going to fundamental concepts of justice and of the American system. And finally, before I end, I want to turn to what Thomas Jefferson thought of this case. And he wrote Abigail Adams in 1804. But the opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves and their own sphere of action, but for the legislature and the executive, would make the judiciary a despotic branch. So Jefferson didn't like that aspect. And in an 1850 letter, he said, the question whether judges are invested with exclusive authority to decide on the constitutionality of a law has been a subject of consideration with me in the exercise of official duties. Certainly, there's not a word in the Constitution which has given that power to them more than to the executive or legislative branches. And so I end with saying the problem with Marbury versus Madison is a case where there's nothing wrong with necessarily with giving the Supreme Court the power to declare laws unconstitutional. The problem was that it wasn't contemplated in the original Constitution, and therefore we've ended up with a judiciary that many people like Jefferson think is a despotic branch or is not one that is responsive to the people. And so that is William Marbury, the man who made the Supreme Court supreme. Thank you.
Okay, thank you so much, Jim. Again, if anyone has any questions, you can use the Q&A function. We do have a couple that have come through here. If Jim can get a chance to turn his camera on there.
I'll start video.
There you go. Okay. And actually, I'm going to stop your screen share too. So
Oh,
that way we can just see you.
okay.
Okay.
Thank
All
you.
right. So again, if any questions, someone asks, was Marbury the youngest son?
Yes, he was the youngest son.
Okay. And then why was Benjamin Stoddard involved in the case?
Benjamin Stoddard was not involved. He was not a named party in the case, but the whole scheme was for the Columbia Bank of Georgetown to get these justices of the peace position. And so he was very interested in it. But in fact, he went into debt, and I think went into debtor's prison, moved out of Georgetown, and moved over to Maryland side, and he took over his father-in-law's house.
Okay. Next question here. Again, this is probably, this might be straying into more legal question, but Judge Barrett says she is an originalist and that Marbury versus Madison is settled. Is there a conflict between these views?
No, I think everybody would pretty much say that, you can't go back and revisit Marbury versus Madison at this point. Our whole legal system now depends on it. So that if you made a change to Marbury versus Madison, that should be done by constitutional amendment. Although there are a number of legislative solutions to it. One of them is to expand the court, but another one, which is more appealing to me, is to change the process for nominating the judges to make justices, to make that less political and to vest that power in somebody other than the Congress, Senate alone.
Okay. Why, if Marbury filed his case as a government official, did Marshall send it back down to an appellate court?
It was sent back to a trial. It wasn't sent back. It was just dismissed altogether. But Marbury was not a government official. And in any event, it's a good question. Marshall just said that clause of the Constitution does not apply to Marbury.
Okay. Is there a legislative mechanism to override a Supreme Court decision?
No, there is in England, but not in the United States, except by a constitutional amendment.
Okay. Let's see here. Even if Marbury wanted to pursue the case in a lower court, was there a district court in DC at the time? Had it been created by Congress?
Yes, there was a district court in DC. He could have, the case was not decided until 1803. He had filed it in December of 1801. It was decided in February of 1803. I think he thought he had better things to do.
Okay. What happened to Hamilton the slave?
I never could find out. All I could get was his inventory of the estate, which he was in the estate, and the will, which freed him, but I never could figure out what happened to him.
Okay. Do we know when and under what circumstances the justice of the peace system ceased?
Well, it's still around today, but in 1800 in Georgetown and in Montgomery County as well, it was more like a county council. They had limited authority to spend money, but they were more like a county council. And then they also had this criminal jurisdiction. But you find justices of the peace around. I know I practiced law in Missouri, and they had justices of the peace. It was a small claims court. Anything under, I think, $5,000 or $10,000 they could handle if you want, and it was cheap. It was you didn't need to have a lawyer. You could just go in and try your case. It was like a small claims court.
Okay, someone says, fascinating that Marbury House ended up with the Ukrainians. Was it in private hands before that? When did the Ukrainians take possession approximately?
I think John Marbury passed away in like 1880s. So once he passed away, it went, I think there was it was still a private house by a person who bought it from his estate. But after that, it then became, sadly, an apartment house. It was cut up into apartments. Ukraine bought it, I believe, in 1990s, and it was just a total mess. And they spent millions of dollars to renovate it and restore it to how it looked in Marbury's day. So they did a fantastic job with it.
Someone asks, do you find the level of partisan shenanigans demonstrated here shocking? I do.
Well, if you look at what happened in 1800, you mean in the Marbury case? No,
I believe so, yes.
yeah, no, I think I sort of go into that because we think of the founders as these, grand godlike creatures, and they weren't. They were very partisan and petty little men. They were surprisingly talented, but they were often out for their own financial benefit and very strong political views.
Partisan politics has probably been the defining aspect of American politics since the beginning.
Right.
Okay. Someone says, I was not aware that the land for the federal district was purchased. I thought it was ceded. Can you talk a little bit more about this?
Yeah, I can, because I spent a lot of time in the past few days preparing for this. Originally, when I gave this talk, the seated thing, somehow that got in my mind too, and I couldn't find that. But there is this. It's a good question, because I wanted to talk about this. The part of the story about what happened at that dinner was that one version I heard was that Washington walked into these 19 landowners and said, I'm going to make you an offer you can't refuse. You're going to give me half your land for the District of Columbia. And they said, oh no, that's an easy offer to refuse. We're not going to give you the land. And Washington said, well, the reason you're going to do that is because I'll take half your land and the other half will then more than double in value. So you'll get a lot of money out of that. But if you don't take my offer, I'll go build the capital somewhere else and you won't have, you'll be out of pocket. So that's the version I've heard about ceded to the government. I think, in fact, both sort of happened, that Washington was able to sweet talk some of the landowners into donating their land because the remaining land would become so valuable. But I know that they did buy some of the land.
Okay. Last question. Last question I've got here, unless any more come up, is would term limiting Supreme Court judges require a constitutional amendment?
Yes, it would. The Constitution says all federal judges are judges for life. And that's a good thing because it means they don't have to worry about reelection. They don't have to worry about their time ending. They can stay on as long as they want. Most of them retire when they find they're slowing down. But at least in legal circles, that's regarded as a very important aspect of a federal judgeship.
Okay, and then I did just get one more question come in here, and I guess we haven't quite hit 3 o'clock yet, so we'll do one more. With respect to the clash between originalism and Marshall's reasoning in the case, given we cannot realistically reverse Marbury, isn't the better answer to dismiss the originalist theory?
Well, I think so. It's just Justice Scalia came up with this idea. And now Amy Barrett says that she is going to follow it. And I think Clarence Thomas follows it. But I think a good number of legal scholars, probably a majority, don't think it's a good idea. They think it's sort of nonsense, in fact. Because take, for example, the right of privacy, which Roe versus Wade is founded on. There's a lot in the Constitution that about protecting, our homes are sacred and stuff like that. But technology has changed so much, so you can't take the Constitution with the original wording and the original meaning. And I think even originalists will say that. But I think until Antonin Scalia got on the court, the general view was nobody ever thought about originalism. They always just thought about what's this Constitution about? What essential principles does it establish in the amendments, and especially in the Bill of Rights?
Okay, all right, I did get one more that I think is a really good question, and again, this will be the last one, I promise. But this one I think is very good because it's important to answer. Why is it Marbury versus Madison and not Marbury versus Jefferson?
That is a good question. It is because Madison was the Secretary of State, and he was the man who ran the government. And Marbury actually wanted a thing called a writ of mandamus, which is something saying, you know, somebody has to do something. And what Marbury wanted was Madison to deliver the commission to him.
Okay. All right. We're going to go ahead and stop questions there. Jim, thanks so much. Any closing thoughts or last minute comments you'd like to add?
I just want, and if anyone wants to read this article, it's on my website. It's called A Different Look at Marbury. And my website is www.jameshjohnston.com, Johnston with the T. And there in the upper left, you'll see publications. If you click on that, you'll see all my publications. And it's a publication for Legal Times in 2005 on Marbury.
Okay. All right. Again, thanks everyone for joining us. Next week, we'll have a rewind, and we will have a recording of this posted on our website later this week. Thanks again, Jim.
Thank
and
you.
We'll see you later.
Thank you all.
All right. Bye.